consolidation is permitted when two or more suits are before the same court. In light of the above, I have would be added on the indictment in Masaka. In Masaka CRB 605 of 2021, and the two would be handled as one. This is clearly joinder of persons and offences and not consolidation of criminal matters. In the spirit of administering substantive justice, this court will exercise its discretion and treat this application as if it was an application for joinder of offences and persons, so as to conclude it on its own merit. This therefore takes me to the second issue, which I will rephrase as follows. Whether the persons and offences in the realm of CRB 203 of 2021 can be joined on the charge sheet or indictment of Masaka CRB 605 of 2021 that is before this honorable court and be handled as one. Honorable Elias Lukwago submitted that Masaka CRB 605 of 2021 and Rengo CRB 203 of 2021 arise from a series of the same transactions and therefore should be handled together in order to avoid abuse of court process. It was his contention that the two cases are inextricably intertwined so much that one cannot be divorced from the other. We gave a chronology of the events and submitted that the charges in Rengo CRB 203 of 2021 were as a result of a series of murders that happened in Greater Masaka, and it only came after the applicants had been granted bail by the High Court in Masaka. High Court in Masaka, CRB 605 of 2021. He wondered why Rengo CRB 203 of 2021 did not come first, since it indicates that the offense was committed on 2nd August 2021, which is way before the other murders which are said to have happened on 23rd August 2021. He further argued that Rengo is part of Greater Masaka, and the offense in Rengo CRB 203 of 2021 is part of a series of murders that were happening in Masaka at the time and are acts of terrorism. On the other hand, Chief Secretary Richard B. Bunka, while citing sections 23 and 24 of the CIA, which regulates framing of charges in criminal matters, vehemently opposed the joinder of offences and the persons. He submitted that the offences and the persons in the two case files cannot be joined in the same indictment. Otherwise, there would be a misjoinder and resultantly a miscarriage of justice. He contended that the parties in the two cases are completely different for the applicants, except for the applicants who appear in both. He also argued that the offences were committed at different times, in different places with different facts and different motives. He further argued that whereas in Masaka CRB 605 of 2021, the motive of the murders was terrorism, in Rengo CRB 204 of 2021, the murder was an isolated incident and the motive is unknown. He finally submitted that allowing joinder would mean charging all the people afresh and committing them for trial and let them undergo a fresh prepared process which would cause more delay. In order to resolve issue 2, this court will be expected to answer 2 questions, namely, 1, can the offences in the 2 case files be joined and charged in one charge sheet or indictment? And B, or 2, can the persons in the 2 case files be joined in one charge sheet or indictment. The law governing joinder of counts in the High Court is provided for under Section 23 of the Trial Indictments Act, and it provides as follows. 1. Any offences, whether felony or misdemeanor, may be charged together in the same indictment if the offences charged are founded on the same facts or form, or are a part of a series of offences of the same or similar character. Whereas more than one offence is charged, number 2, whereas more than one offence is charged in an indictment, a description of each offence or charge shall be set out in a separate paragraph of the indictment called count. Applying the above law to the facts of this application, I find that the offence in the charge sheet of Rengo, CRB 203 of 2021 is murder, and I believe that it is of the same or similar character with the offences in the charge sheet of Massacre, CRB 605 of 2021, within the meaning of Section 23(1) of the KIA. This would therefore mean that the offences may be joined together in the same charge sheet. The first question, therefore, is answered in the affirmative. The other question is, can the person in the two case files be joined in one charge sheet or indictment? Joinder of persons is provided for under Section 24 of the TIA, which provides that 1. Which provides that the following persons may be joined in one indictment and may be tried together. 1. Persons accused of the same offense committed in the course of the same transaction. Persons 2. Persons accused of an offense and persons accused of abatement or of an attempt to commit that offense. 3. Persons of more offenses than one of the same kind. That is to say, brackets, that is to say, offenses punishable with the same amount of punishment under the same section of the Penal Code Act or any other written law committed by them jointly within a period of 12 months. And 4, persons accused of different offenses committed in the course of the same transaction. It goes on up to 6. Considering the facts in the instant case, the only provision that would be applicable is Section 24, subsection 3 of the TIA. If the applicants were the only accused persons appearing on the charge sheet of Rengo, CRB 203 of 2021, then they would safely be added to the charge sheet of Massacre CRB 605 of 2021. This is because the applicants would be, and I quote, persons accused of more offenses than one of the same kind, brackets, that is to say, offenses punishable with the same amount of punishment under the same section of the Penal Code Act or of any other written law committed by them jointly within a period of 12 months. However, there is another accused person, namely Ssewanyana Wilson alias Nyonga Tony A3, on the charge sheet of Rengo CRB 203 of 2021, which makes the joinder of persons impracticable. Besides, Massacre CRB 605 of 2021 also has 5 other accused persons in addition to the applicants. Had it been that A3 also appears as one of the accused persons in Massacre CRB 605 of 2021, or there were no other accused persons on the charge sheet of Massacre CRB 605 of 2021, then the joinder of persons would be possible. However, A3 is a total stranger to the case as is currently before this court. As such, bringing A3 to the case before this court with the accused persons is not connected to in any way, and for charges he is unaware of, would be a misjoinder of persons. In light of the above, therefore, it is clear that the persons in the charge sheet of Rengo, CRB 203 of 2021, cannot be safely joined on the charge sheet of Massacre CRB 605 of 2021, thereby answering the second question in the negative. Having made that finding, I also find that failure by this court to order for a joinder of counts and persons in the 2 case files that are the subject of this application does not in any way violate the applicant's right to a fair hearing and is not prejudicial to them in any way, the two matters can be safely handled separately. Counsel for the applicants emphasizes that charging of the applicants in two separate files is an infringement of the right to fair hearing as enshrined in Article 28(1) and subclause 1 and 9 of the Constitution, which provide for the right to a fair and speedy trial and the right against double jeopardy. Though the Supreme Court has stayed the execution of the judgment of the Kazinda case, on which counsel for the applicants based their submissions for this argument, I believe this court has ability to give its view on the right to a fair hearing as enshrined in Article 28, clause 1 and 9 of the Constitution in light of the facts of the case. My view is that charging the applicants in two case files does not deny them their right to a fair and speedy trial because, as this court was informed, in both case files, the accused persons have already been committed to the High Court for trial. Counsel for the applicants also contended that charging the applicants in the two case files amounts to double jeopardy. Double jeopardy is provided for under Article 28 and Clause 9 of the Constitution, provides as follows. A person who shows that he or she has been tried by a competent court for a criminal offense and no evidence was adduced to the satisfaction of this court to that effect. In conclusion, this application hereby fails and is accordingly dismissed with no order to post.
My Lord, we oblige that before we do respectfully. I'm just putting counsel records. It's not something major. It may be recorded that the Honorable Shamim Malende came in with the proceeding. May she be put on record as present. Thank you, Lord.
What is is there anything else you want to say?
Yes, the last one, my Lord.
Mr. Muizu,
Yes.
that was it.
Yes, that was it. Not in the previous ruling, it was single.
Apologies for that.
My Lord, we have been pending application for bail before you. Whereupon, due to the decision just handed down to us this morning, leaves this court to the discretion on whether to fix that application or not.
You want me to fix it?
Yes, we would prefer that the same be fixed. Would oblige.
You want me to fix a bail application?
No, wait.
Mr.
William Sima.
Yes. You want me to fix a bail application? Because I don't want us to waste time. If I have said I don't have the massacre file and I cannot pick it from my colleague, how do I handle a bail application for a matter that is in massacre? Considering what I have already wrote. I just don't want us to waste time. And let's not this as important, save time. Because you see, we are saying this case should be handled expeditiously. And I am committed to do that. So, fixing it, I have no problem, I can fix it, but you know the result. In light of what I have faced this moment.
Well, there are two things. I don't want to go into this decision.
No, of course you are not supposed to.
I'm not supposed to. It
is
would be unprofessional for me to go into whether you have jurisdiction. Because I would then say there's unlimited jurisdiction. I don't want to walk into this. But again, you have the powers to transfer this file if you believe it is not professional for you.
I thought you also have the responsibility to file your matters in the right court.
My Lord, ante this decision, we knew were properly before you. And we still believe.
So what do you want me to do with the other application, the bail application?
It may be.
Okay, I can give you a date.
Transferred. Yes, ma'am.
Yeah, I can give you a date for it.
Then we can, meanwhile, make a decision on this. Yes, no, we have no problem with that.
You have not been served.
Yeah, that's what part of the
Yeah,
so we haven't been served by
value.
My Lord, just a simple clarity. Especially putting in mind that this honorable court has jurisdiction. Because of not resting,
don't take me there.
most blood. My humble prayer would be, instead of fixing the matter, because we had already fixed the main suit, this honorable court still has the authority and the powers, impossible to transfer the file to the other side. So that at least that case is handled that side, and we proceed with the main cause, Your Honor. Instead of now fixing it, then coming in for hearing and all that.
Now you see, because you represent different people, you are beginning to fight
Exactly. Because I'm mindful about other accused persons before this honorable court.
No, it's okay. I'm giving them a close by date. And yeah, I can actually ask both of you to come if you have not been served so that we resolve this.
Yeah, let's mention that matter before you, for us to have direction on the same. Mention.
Can put it to touch Monday next week.
Well, for mention, you can take it.
No, actually, I'm going to give it a date right now.
Yes.
So you can pick it and serve it to them.
Yes.
Yeah, and I expect them to come on the touch. They have not found the reply.
Yeah, I'm saying let's put it for mention. Any of us can be around, so the date will suffice. Let's just mention that we are on that date. And my clients wanted to state anything, it's within the path of this court to decide whether to hear them.
Okay, I fix information on 3rd of October at 9:30. The bail application. Mr. Bobi, the double Z.
Yes.
Does any of you kind want to say something? I begin with Honorable Ssewanyana. Please.
Thank you, Your Lordship. Your Lordship, we have just received disturbing news this morning from our lawyers that you have made a decision to hear ex parte an application for witness protection from the state or from the prosecution side. Mindful of our status, mindful of the kind of jobs that we do, Your Worship. We get these jobs through a competition. We have enemies as members of parliament. We know that anything can happen, especially in regard to witness protection. We have people in our constituencies who lost jobs in favor of us who became members of parliament. We go through a competitive process.
Those ones who supported you?
Those who supported us and those who did not support us, they are all there. So we are very mindful of why the state is asking for witness protection, because he can do anything, can get anyone, any of our competitors to come to court here. We are very mindful of that, Your Worship. So that's why we are given orders to our lawyers to be party to that application and make substantive arguments in favor of us as they are chosen. We don't fail to be having a fair trial if the ones who are going to give who are going to be witnesses in our case, are going to be protected, are going to be closed from us and the public, are going to be hidden.
I can cut you short.
Yes.
I can cut you short and tell you that I don't know whether your lawyers shared with you the ruling that I made. If they did not, then they should, so that you get to know the reasoning why I said that application should be ex parte, because the law allows ex parte, actually provides for mandatory ex parte application. But to allay your fears is that the court has not made any orders yet in that application. And that is what we are going to listen to from them. And court, you just be comforted that court cannot, you cannot allow you to be tried by ambush. That application that they have sought, which is ex parte, is for me to determine whether they should disclose to you when and how. Have you got it? So I've not allowed them not to disclose at all. I am going to assess their arguments and then I will make a decision. So you don't have to be worried about that.
Thank you.
Honorable Ssegirinya, is there anything you want to say? Okay. Okay, I wish you a good day. And I will give you a ruling that will sign copy of the ruling in the next 30 minutes.
The chairs.
Habla, basaze ekikulu.
Agonda omutima baana bano tebalina musango bakukulu tebalina musango gonda omutima baana bano basumulule baveeyo kuba balina be balina okuweereza n'abaana bano babonyeza sikitegeera na kutegeeza baana baffe ne babeera mu mbeere ondo mutima
Embeera nga bwe mugiraba mwenna, yes, tuli wano ku ICD Court Kololo. Embeera ya kiyongobera ababaka babiri mu balabi Ssegirinya ne Ssewanyana baddiziddwayo kati mukomera. Wabula tubadde tuzzi wano nga twasaba kkooti egatta emisango gyonna wamu, wabula emisango gino kkooti egambye tegisobola kugattibwa olw'ensonga nti fayiro esooka eriko abawawabi babasukka abali abasatu, ate nga ne ku fayiro eyasooka kuliko abawabi babasukka 7. So ntera okuba nti abantu banjawulo, emisango gya njawulomu, negamba nti tejja kusobola kugatta fayiro ezo. So tujja kuba kino kitegeeza tujja kuba nga tulina okugendanga e Masaka tuwoze olw'ababaka ate tubeerenga wano ku ICD Kololo e Kampala. So embeera bwetyo bweyimiridde mpozi n'ensonga y'ababaka gye babadde beekubira omulango okuba nti babagambye nti abajulizi 17 bagenda kuwa obujulizi nga beekwese. Ekyo balaba nga kintu kya bulabe nnyo, naye omulamuzi agambye nti agenda kulaba engeri gy'anaakikolamu kasooka awuliriza okusaba kwa state. So tuli wano ku ICD Court.
Council giving yes. Just giving abatulaba mwenna yo Honorable Shami Malende nga tuli wano ku ICD Court. Ng'olunaku lwa leero ba defense councils baali basaba omulundi oguwedde nga basaba fayiro zino zombi ezivunaanibwa ababaka zigattibwe efuuke fayiro emu. Omulamuzi olunaku lwa leero atuwadde ruling era n'agaana nti fayiro zino ziri mu kooti za njawulo era n'amadala kooti gwe ziriko ga njawulo. So agambye bajja kusigala nga balina cases zaabwe 2, ey'e Masaka n'eno eri e Kampala mu International Criminal Division ICD Court. Yes, mwebale nnyo, mwebale ddala okubeerako, mwebale nnyo ku support era nga mbaagaliza olunaku olulungi, musibe mulungi, mweraba.